Hello everybody, my name is Dave Menchetti and I'm with the Chicago law firm of Cullen, Haskins, Nicholson, Menchetti, and we concentrate our practice in representing injured workers. Today we're going to be talking about AMA impairment ratings and how they affect workers' compensation cases in Illinois. So to begin with, we'll start with takeaway number 1, which is to know Section 8.1b of the Workers' Compensation Act. The first thing that you should know about Section 8.1b is that it applies to injuries on or after September 1, 2011. The next thing you should know about Section 8.1b is that it lists 5 factors that go into the determination of permanent partial disability. Those 5 factors being age, occupation, future earning capacity, evidence of disability corroborated by the treating medical records, and finally the factor that brings us here today, which is AMA impairment rating done pursuant to Section 8.1b and the AMA Guides to Permanent Impairment. Notice that Section 8.1b requires that the AMA impairment rating in a workers' compensation case be done pursuant to the most current version of the AMA Guides, and that version is currently the 6th edition of the AMA Guides, and it's in a book that looks like this. So this is the version of the AMA Guides that is required to be used under Illinois law, and if you're going to be doing any of this type of work, you should invest in this book. It's available from any of the online book sellers, and the most important 2 chapters of this book for lawyers' purposes are the first 2 chapters, Chapter 1 and Chapter 2. So the second takeaway point is to know what an AMA impairment rating is and to know how it's performed. So an AMA impairment rating is a consensus-derived percentage estimate of the severity of an injury. Under Illinois law and under Section 8.1b, that percentage estimate is supposed to be done by a physician licensed to practice medicine in all of its branches. And in Illinois, what that means is that chiropractors cannot do AMA impairment ratings. An AMA impairment rating is derived from a particular methodology in that 6th edition of the guides that I showed you earlier. And that methodology involves the use of a key factor called a diagnosis-based impairment. Once the diagnosis-based impairment is derived, it can be adjusted or modified by 3 other factors, which would include physical examination findings, clinical study findings, and a functional history. The result of this methodology used to derive an AMA impairment rating ends up being a percentage loss of use of the injured body part. So something comparable to a permanent partial disability evaluation in a workers' compensation case. For example, for a rotator cuff injury with a full thickness tear, the AMA impairment rating might be something like 6% of the upper extremity, which would then be translated into a whole person impairment, or WPI, of 4%. So that's how AMA impairment ratings are derived, and that's what an AMA impairment rating is. The third takeaway point that I'd like you to have is that impairment is not the same thing as permanent partial disability. The guides themselves are very clear on this point, and the guides themselves say that the relationship between impairment and permanent partial disability is complex and difficult, if not impossible, to translate directly. So don't be fooled. Even though an AMA impairment rating might look a lot like a permanent partial disability award to the extent that it involves a percentage loss of use of an affected body part, an AMA impairment rating is emphatically not the same thing as permanent partial disability. In fact, the guides themselves say that an AMA impairment rating is only one of the factors that should be used in determining disability. So just as Section 8.1b of the Workers' Compensation Act requires the evaluation of 4 other factors, including the AMA impairment rating, so do the guides say that an AMA impairment rating is only part of the evaluation of disability. Commission and arbitration decisions that have been decided under Section 8.1b make this point very emphatically, and those decisions almost always say that impairment is not the equivalent of permanent partial disability, and that the evaluation of permanent partial disability is something more than simply or merely the calculation of the impairment rating. So if there's only one thing that you take away from this very short presentation, this should be it. Permanent partial disability is more than simply an impairment rating. So takeaway number 4 is to know how to bolster or diminish the credibility and weight of an AMA impairment rating. So now that we know a little bit about how AMA impairment ratings are done and what they mean, you're going to want to know how to use them in your workers' compensation cases. And I suppose that depends on your perspective. If you're a lawyer who represents employers, what you're going to want to do is bolster the credibility or weight of an AMA impairment rating in order to reduce the value of the permanent partial disability award. So no matter which side you represent, whether you represent employers or injured workers, it's important to assign weight to an AMA impairment rating, and you should always do that in your proposed decision to an arbitrator. And it's not uncommon in these decisions to see phrases like little weight or moderate weight or great weight. So those are the kinds of phrases that you should use in order to bolster or diminish the weight of your AMA impairment rating. So the 5th takeaway is to know how to examine or cross-examine an AMA impairment rater. In my opinion, the best way to bolster or diminish the credibility and weight of an AMA impairment rating is to examine or cross-examine the AMA impairment rating expert. I think there are 3 general areas in which an AMA impairment rater can be questioned. First of all, I think an AMA impairment rater can be questioned on the philosophy of the AMA guides. In other words, why the AMA guides to permanent impairment exist. I think the second general area in which an AMA impairment rater can be questioned is the form of the AMA rating itself, or how that AMA rating was done and what methodology was followed to establish that rating. And third, I think that the substance of the AMA rating can be questioned. In other words, what was done to determine the AMA impairment rating. So, whatever side of the fence you represent, whether you represent employers or injured workers, I think it's important to examine or cross-examine an AMA impairment rater on at least those 3 areas. Those are just some general ideas of how to examine or cross-examine an AMA impairment rater. I'm happy to share any specifics that anybody would like to talk with me about at any time, so please feel free to contact me if you'd like to talk about more detail. For more information on AMA impairment ratings in workers' compensation cases, please view my full presentation recorded during the Workers' Compensation Update Program, now available in the ISBA online CLE archives. And to learn more about the benefits of joining our ISBA Workers' Compensation Law section, which sponsored this great CLE program, check the ISBA website.